All right, let's try this again. Hello, everybody, and welcome to this program. It's only going to get worse than it is now. The moderator is already moving his lips, hasn't taken a lesson in months, and I am just going to tell you right now this is a 50-minute session. It'll seem much longer, and you probably won't learn much. I would definitely put on the headphones and watch something else. If you're watching this for continuing education, then you're really wasting your time. Anyway, here's the presenter, and don't let him know what I said. He's hard of hearing. Okay, thank you for that rousing introduction. I am Alan Gassman. I'm a lawyer in Clearwater, Florida, and on most Saturdays I am here at 11 o'clock to talk to my friends because I don't have any real friends. And this presentation is on adjusting estate plans for the $15 million exemption for families who are below $15 million per parent. So things have changed and things are going to continue to change. Change, as you know, is inevitable. And here we go. Now, the first error of the webinar is that this is a 50-minute webinar, not a 1 hour and 50-minute webinar. I'm going to talk on this topic until 11:50, and then at 11:50, I'm going to switch over and show you what's new with EstateView software, if that's of interest, and we'll run some numbers for people who are in this little bit awkward situation where they have less than $15 million per spouse, but they may have more later, and now they have a lot more things that they're interested in that we can talk about and talk about resituating. If you'd like a free trial on EstateView, just open your browser, go to estateview.link, and follow the instructions. Your secret password is free trial, and you'll get a 10-day free trial. I apologize for the smallness of this slide, but it does give you some upcoming events. I hope to see you financial planners at the National Association of PFA September 5th. I'll be talking on asset protection and qualified personal residence trusts. Then if you're an orthopod, I will see you in Washington, D.C. September 15th to talk about asset protection. And if you are in Sarasota or would like to come to Sarasota, I will be there September 16th in the morning talking about essentials of Florida asset protection, and at the lunchtime talking about spousal limited access trusts with the Sarasota Foundation. So I'm very much looking forward to that. Notre Dame Tax Institute is coming up. Please sign up for the Notre Dame Tax Institute. It will be November 5th, 6th, and 7th. It's all cyber this year. A lot of really good programs. You can watch it live, or you can watch it later, or you can do half and half. But Jerry has done his normal, wonderful, wonderful event there. And then Wednesday, October 22nd, the United Jewish Appeal from New York Sid Kess program is another one not to be missed. Marty Shinkman's working really hard to make that a nice program. So my hat's off and my sympathies to all of the people who run these programs. It's a lot of work, and they deserve to be supportive, especially if they've invited me or one of my puppets to speak there. If you are more of a glutton, you can attend one of our free EstateView masterclasses with Peter Farrell, who's a very bright tax lawyer with our firm. And those are Wednesdays and Fridays at noon Eastern Standard Time. And if you're an EstateView user, you can bring all your questions or even bring a hypothetical and watch Peter walk through it in front of you. Or if you're not an EstateView subscriber, you are still welcome as long as you buy a timeshare at the end of the 1 hour session. You can go to estateview.com and watch videos on a lot of different planning techniques. And now enough of the shameless self-promotion. A lot of these slides are from a Lineberg Information Services webinar that I recently gave with Marty Shinkman and Barry Flagg. I want to thank Barry Flagg for his infinite patience with me whenever I try to learn about life insurance or understand a particular life insurance situation. Uh, One thing that comes to mind, and I'll mention this a number of times, but think about it this way. A lot of people have purchased life insurance policies for certain reasons, such as give me a lot of death benefit to pay estate tax, or give me a lot of cash value because I want this to be an efficient income tax planning device. Well, those things may change now. So we'll talk about that, but analyzing these policies and not necessarily saying to the agent of record, what can I do? And the agent of record says, do this. Do you get a second opinion? Do you have a technically oriented agent of record who can give you 5 or 6 alternatives? Is there a better policy that you can exchange into that's more cost effective? Those are all things that come to mind with respect to this. So I'm going to start here with Bob and Mary. And Bob and Mary are, let's say, in their 60s, and they're completely exhausted and tired of me because in order to get their estates down to below the $7 million per spouse exemption that we thought we would be working on under, they have a bunch of trusts. And when we get together and they review their complicated chart, they always say, what's this trust for? What's that trust for? What's this trust for? What's that trust for? And the answer is, well, this one helped me put my daughter through college. This one helped me put my son through college. And this one helped pay for my Porsche. But the real answer is, for the most part, we were trying to save federal estate tax. So Bob, and I'll pull my cursor up here, Bob set up a spousal limited access trust in the form of a life insurance trust. So that has two names. It's an ILIT, an irrevocable life insurance trust, and it's a SLAT because it was for the benefit of Mary and their descendants. And SLAT stands for Spousal Limited Access Trust. And it has a life insurance on Bob in it. And there were some reasons for that life insurance policy. One was that if Bob died early, before they had accumulated enough wealth to support Mary, there was a death benefit that would be there for Mary. Secondly, they expected there to be a federal estate tax. They may have put this in place when the estate tax exemption was only $1 million. I clearly remember back then, or only 3.5 million, which we thought was a lot. And now there is no more estate tax. So what are we going to do with that life insurance policy? What are we going to do with that life insurance trust? We're going to talk about that. And then Bob has a SLAT, a spousal limited access trust, to hold investments or to hold his business company or a big part of his business company. And that SLAT owes him a note. So the business company may have been worth 15 million and we sold 99% of it to the SLAT for a 10 million note. That reduced his estate from 15 million to 10 million, and all those nice dividends are going into the SLAT, and he's owed $10 million. And now the SLAT is worth $40 million, and he's only worth $10 million. And his children are going to be much wealthier than he ever was, and perhaps than he will ever be. So what are we going to do now with that SLAT? And then their home is in a qualified personal residence trust, which was perfect for them because they wanted to live in their home forever. It was their forever home. It still is their forever home. And they were able to put it into a trust that allowed them to use it without paying any rent for the first 20 years. And after the 20th year, the house is out of their estate. And they're really happy about having the house out of their estate. But now they're paying rent to use the house. That gets the rent out of their estate, but they don't know if they want to pay rent anymore. And they realize that after they die, when the children sell the house, in order to have a big party, they're going to have to pay capital gains tax according to the IRS. And Revenue Ruling 2023-2. You don't get a new income tax basis when the grantor of a grant or trust dies when the assets are out of his or her estate. I don't agree with the IRS on that, and I hope eventually this will be litigated in favor of taxpayers, but this is the IRS position. So what are we going to do with that house in the Cupert? Because page 3 of the Cupert says the grantor and the grantor's spouse may not buy the house back directly or indirectly. And then Mary's got a revocable trust. And you see below that revocable trust that in order to avoid federal estate tax, they did what Jackie Onassis did. And what did Jackie Onassis do? Well, she married a very wealthy person who was in shipping, and she became the equivalent of a billionaire, I'm sure. And she put in her estate plan that to the extent that my estate exceeds what can pass estate tax free, the share of each of my children, instead of going to that child and having to pay a lot of estate tax, can go to a charitable lead annuity trust, which will pay charity for 20 years. And then after 20 years, there'll be a lot left for my child. She left it up to each child to decide how much would go to the CLAT. The children said, forget the CLAT. We'll pay the estate tax, take the money now. But it was still a nice thing that she did and that her tax lawyer did to set that up. You know, when she died, they never even mentioned the tax lawyer who drafted the charitable lead annuity trust. That really upset me. But in any event, now Bob and Mary are maybe below the exemption, and nothing's going to go to the charitable lead annuity trust. But, you know, they had thought that something was going to go to charity. But now, if they die under the exemption, nothing will go to charity. So maybe they want to change their estate plan to have something to go to charity. Then Mary had a little lamb and a life insurance trust for descendants. Now, Mary may have had a life insurance trust for Bob and descendants because her lawyer may not have ever heard of something called the reciprocal trust doctrine. And as a result of that, both of these islets may be subject to estate tax in Mary and Bob's estate when they die, and they don't even know it. So you'd have to take that into consideration because you will see a lot of these reciprocal trusts. And then they have the second to die life insurance policy in an irrevocable trust owning that policy. And they've been making annual gifts to that trust every year. Bob's been making annual gifts to the life insurance trust. Do they have to keep doing that? Or can they do something else? And then how am I even relevant to Bob and Mary anymore? Other than they're still upset with me because of how complicated their estate plan is. How can I simplify this? Should we simplify this? And if they don't need me to help them save estate tax, can I now help them do better asset protection planning? And can I help them do better income tax planning? And the answer to all of those things is IHS. I hope so. So I might write a letter to Bob and Angie, and I have the letter here, and you can now go play golf and read the letter on your own. One thing I can do, and that I should do, is just double check on where they are financially and run numbers for them. I'll show this to you after the 50 minutes. But I have an example here of Bob and Mary, age 70 and 64, saving $250,000 a year until Bob's 78. Then he'll save $100,000 a year. After Bob's gone, Mary will save $100,000 a year from pensions and things like that. They've got a net worth of $30 million, house of $3 million. On the first death, he can fund a credit shelter trust of $20,800,000. They've got some life insurance. And right now, if they both die, there's a little estate tax. It's not that much. It's $6.7 million. If they use a charitable lead annuity trust, there's no estate tax, and then their children would get about 43 million. No, actually 46 million if they die. The clat would get a lot, and then on the second death, the children would get more. And that doesn't sound like a bad estate plan to them if the charity gets the equivalent of about $5 or $6 million. But on the other hand, if their assets grow at about 5%, 7.5% minus 0.4% in management fees and costs, and 2% per year of income tax, in 10 years, they'll be worth $55 million, plus they'll still have that life insurance that they bought. And in 20 years, 86 million, estate tax 26 million, total passing to beneficiaries 80 million. And then I can show them the credit shelter trust brings that tax down to 23 million. Annual gifting for their children, if they continue to do it, brings it down to 21 million. A large gift to a gifting trust, turn their life insurance into life insurance trusts, 17 million. A large gift of a third of their assets with a discount brings it down to 13 million. That's still a big percentage of their estate. Look at that. And then if they want to do no more, they say, well, that's not bad. The kids still get this amount. I don't want to do a lot of fancy stuff. How much should I leave in a charitable lead annuity trust? And the answer is, instead of 91 million going to your children with 13 million tax, 70 million goes to your children, 34 million goes to the charitable lead annuity trust. It pays your favorite charity, which could be your family foundation run by your children, a certain amount each year. And you might expect that about half of the wealth ends up in the charity, and after 20 years, the other half of that wealth goes back to the kids. They end up with 88 million. Not a bad gig, and that may be all that this family needs to think about. But you really have to make sure your clients understand that the values go up with time, and so does the estate tax. Now, the same people, what if the estate tax exemption goes down by half in 2030? So what we're doing now with EstateView is, for most of our calculators, you'll run it two ways. One, based upon a 15 million exemption going up with chained inflation, and two, based upon the exemption going down by half in 2030. Well, now the odds are more severe. You see before the CLAT, the estate tax at 13 million, CLAT's bigger, and look at the CLAT as a percentage of assets on death. That's a pretty big CLAT, but then on the second death, you see half the CLAT. Oh, lightning just struck. I guess Mother Nature didn't like what I'm doing. Okay, now, what can we do between Bob and his eyelet? And remember that a preposition is anything that a squirrel can do to a tree. That's what my third grade teacher taught me. You can go up the tree, down the tree, across the tree, over the tree, under the tree. Those are all prepositions. What can Bob do with his eyelet? Well, the first thing, he can just keep it as it is, keep making the premium payments, maybe have somebody responsible run some scenarios to show him how to best maximize the economics of that policy by paying more or less. But that's the status quo. Or he could just reduce the death benefit on that eyelet. Let's say it's a $5 million policy with a $1 million cash value. The cash value would support a $4 million policy. Reduce the death benefit by $1 million. It's now a $4 million policy. Don't worry about it. That might be the best thing to do, but if it's a whole life policy, he may lose a lot of cash value by not making the premium payments. So you have to run the numbers. You have to ask the carrier for what's known as an in-force ledger, showing all the different alternatives, and then have somebody who knows what they're doing take a look at that in-force ledger. Number 3, he says, I like the status quo. I want to keep making the payments, but I may need the money back. Well, now, instead of making the premiums as gifts to the trust, he can make them as loans to the trust, and maybe he'll charge 7 or 8% interest. He cannot charge more than the going rate. That could cause the trust to be subject to estate tax if it could be shown that there was some sort of pre-existing arrangement between him and the trustee that he could take economic benefit of the trust. But he could certainly loan to the trust at, say, 6%. He could use what's called a split dollar loan arrangement and take a lien on that policy. And come heck or high water, he's going to get paid if that policy gets cashed in. Or maybe Mary gets paid if the policy matures, which is what happens when a policy pays cash on death. Now, if he loans the money instead of gifting it, but whether he's a split dollar or a conventional loan, he might consider having the ILET swap that policy for a policy that pays long-term care expenses. That's one repurposing. Most of these policies there were put in place for estate tax and liquidity and maybe income tax planning. But now as people get older, they say, what about nursing home expenses? How am I going to get an attractive nurse in my house if I need nursing care? And the answer is you might be able to use a life insurance policy that lets you invade up to twice the cash value for nursing expenses, and that's paid for within the policy by the earnings on the cash value, so it is tax advantaged. And if the life insurance trust owes you money, then it could use that. It could repay you the money at the time that it makes the withdrawals to pay the nursing home expenses, or it will keep the money and you will not have to spend your own money later, or your children's inheritance will not be less as a result of it. And then 5th, there's something kind of fancy called premium financing, where a third party, such as Northern Trust, has a large premium lending operation. And maybe they'll loan you the money to pay the premiums and take the policy as collateral. And if the policy rates of return exceed the interest rate charged by them, you're in good shape. If not, then not so much. So that's if you keep the policy in the ILET. What if you take the policy out of the ILET? Well, let's say Bob has a $300,000 cash value in the ILET and $3 million worth of stock and bond portfolios assets. So he puts $300,000 from the stock and bond portfolio into the ILET, and he takes the $300,000 cash value policy out of the ILET in exchange for that. And then he uses that policy for income tax planning by fattening it up. There is something called the minimum corridor, and the minimum corridor is the maximum amount of cash that you can put into a life insurance policy without it becoming taxable. And life insurance has a lot of tax loopholes on its side, such as you can pull out what you put in, the basis of the policy. You can pull out tax-free anytime you want. You can borrow the rest as long as you don't default on the loan, and when you die, the loan gets eliminated. So it's a way to get tax-free money. So Bob may want to do that. He may want to fatten that policy up so much that it becomes what we call a modified endowment contract. Once that happens, it's more income tax efficient as long as you never touch it, but you can't borrow from it or withdraw from it, or you trigger taxation. He might buy the policy from the ILET and convert it to another type of life insurance. If it's worth a lot more than what he paid for it, as opposed to triggering ordinary income, he might convert it, as I said, to a long-term care policy or a private placement life policy or a variable policy. The ILET may buy 529 plan assets. He knows he wants to buy 529 plan college savings plans. He'd rather not do it from his own money. He'd rather do it with someone else's money. So he puts his money into the ILET in exchange for the life insurance policy. And the life insurance policy is creditor proof. So the $300,000 of stocks and bonds that he owns before this transaction, a creditor could take. But a $300,000 cash value life policy on his life owned by him will be creditor proof in most of the states of the United States, including Florida and New York, where most of our viewers are. And I've got a whole list of those states if you would like to have them. Alternatively, and this would apply to any of these trusts, Bob could buy the life insurance policy out of the trust, put the assets in, and make the trust a non-grantor trust. And we're going to talk more about that in a little while, what a non-grantor trust is. But I'll give you a hint. It is a trust that is not a grantor trust. Here's all the lists. Here's the list of the states which you can have creditor proofness for an unlimited amount, cash value of life insurance on a policy owned on your life. Texas, Florida, New York, Pennsylvania, Illinois, Ohio, Georgia, North Carolina, Michigan, etc., ending with Wyoming. And I have them in alphabetical order as well. Okay, so Mary's ILETs for descendants, the same situation. Second to die policy, same situation. Do they gift the premiums? Do they loan money in the future? Do they borrow money at arm's length? And then it can be repaid after they die by letting the life insurance trust receive some of their assets. Those are all possible. A second to die policy may be a good accumulation vehicle for them, or they may exchange that into a private placement second to die policy, which would have much lower costs and much more flexibility as to what it invests in, or something equivalent thereto. So now I want to talk about the Qualified Personal Residence Trust. And as I said, they put the house into a Qualified Personal Residence Trust. They're happy that it's out of their estate, but they don't need it to be out of their estate anymore. And the trust says they cannot swap assets for the house. So what do? They go to court and they say, Judge, back in 2016, this brilliant tax lawyer, she was the smartest person we ever met. She drafted a trust, and we put our house in the trust to get it out of our estate for federal estate tax purposes. And we don't have an estate tax issue anymore. And it would really be in the best interest of our children and grandchildren to allow us to swap back. We'd like to put some bonds and stock into that trust. We'd like to get the house back out. And our lawyer did donate to your campaign, and we hope you get reelected. And it was great seeing you in church last Sunday. Well, the judge says, I don't know if this is fair to the beneficiaries of this Qualified Personal Residence Trust. I need to appoint an ad litem, who I used to play golf with, to write a report to tell me that this is in the best interest of your descendants. And I know he's good at writing these reports. He wrote one for me recently. Okay, fine. The report gets written. It's good for the descendants, even the minors, even the unborn contingent beneficiaries. The judge takes out that clause. They buy the house out of the Cupert. They use appreciated assets, and everybody's happy. Now, is the IRS going to go back to 2016 and disallow the gift discount? It was $1 million home. it was a 20-year Cupert or a 10-year Cupert, 9-year Cupert, a discount was taken. They only used 600,000 of the exemption instead of $1 million. I don't think that that's going to be an issue. There was no intent to violate the Cupert laws when it happened. They filed a gift tax return. More than 6 years has run since the filing of the gift tax return. Just get that house out of there if you want to get that house out of there. So that's the story on the Cupert. Now let's talk about the slat, but I want to digress so I don't forget to mention buy-sell agreements. So I have a buy-sell agreement with my brother. We own a widget factory, and it manufactures makeup and beauty supplies for home nurses. We think it's worth $20 million, but our buy-sell agreement says to value it at 4 times EBITDA, as determined by our CPA, which would be much less than $20 million. And we set up that buy-sell agreement at the advice of our brilliant tax lawyer. His name is Floyd, and he has pink eye every once in a while. By the way, I was reading last night, the band Pink Floyd is named after 2 1920s, 1930s blues artists from Chicago, Floyd Curtis and Pink Anderson. And I was listening to them last night. They sound nothing like Pink Floyd, but they have beautiful music, really good. And that's extremely important to remember when you design a trust. So, where was I? Bob and the slat. Bob and his brother. Low Russian roulette buy-sell agreement for estate tax purposes. Not anymore. They don't need that. If they're under the exemption, they can go ahead and modify their buy-sell agreement to be true fair market value, so there's no more Russian roulette. And then those life insurance policies that they had in the life insurance trust for estate tax planning, they can be used for the buy-sell agreement now that the purchase price is higher. And then we had that famous U.S. Supreme Court case. It's no longer so famous for a lot of people. It said, be careful, because life insurance owned by the company used to redeem the first dying shareholder will be included in the value of the company, making the company more valuable and the estate tax higher. That's the Connolly case. Well, for Bob and his brother, they want it to be higher now. So the Connolly, they don't have to redraft their buy-sell agreement, although I would never recommend that anyone have life insurance payable to a business company on the death of a shareholder, or even owned by a business company. There's other ways to do that. But coming back now to Bob and his slat. Well, this is where the non-grantor trust magic comes in. And Marty Shinkman and Jonathan Blotmacher believe that there will be thousands of these non-grantor trusts drafted. I'm working on one for myself, and here's the reason why. Marcia and I donate to charity, and we've been having to do what's called bunching, because our itemized deductions this year, our automatic itemized deduction this year will be $32,500. We can deduct up to $10,000 of our property taxes, anything over 7.5% of our medical expenses, then our charitable donations. We don't have interest on a mortgage, so we have to donate a lot to charity before we get over the $32,500. We got an automatic $32,500 deduction. So I've got to give, what, $15,000 to charity, $20,000 to charity before I get any deduction at all? So every 5 years, we could donate, say, $150,000. and get a donation of 130 of that 150, I'm still clipped at about 20,000. I'm glad to do it. I put the 150,000 in our family foundation and in our community foundation account and in our donor advised fund. We have all three of those because I want to make sure I understand them so I can be an example for my clients and because I'm so very generous. But I still got clipped for that $20,000 that was not deductible. Well, Jonathan says, Alan, I have an idea for you. If you want to donate $50,000 a year and you have bonds that pay $50,000 a year of income that you're paying the income tax on, put those bonds into a non-grantor trust, and then under Internal Revenue Code section 642C, which was my grade in taxation in law school the first time I took it, you get the equivalent of a full deduction with no limitation. And I said, that is really good. So I could just put $1 million worth of bonds in a non-grantor trust. It pays the charities, and the trustee can spray the charities. It cannot be a grantor trust, so I can't have certain powers over it, but it can be for the benefit of my descendants. It could be for the benefit of Marcia and my descendants, as long as she's not the trustee, and any distribution to her has to be approved by a non-adverse party. So I could take that slat that has a lot of value, and I could have the trustee of that slat decant some of the slat assets or assets that I swap with the slat into that non-grantor trust and have that new tax efficiency, and I won't have to bunch anymore. I could bungee if I want, but I won't have to bunch, which is bananas. Get it? Bunch of bananas? I'm sorry. I just get bored during these presentations. I got to try the humor. 3 or 4 people actually like the humor, or lack of the humor. So then I say, well, Jonathan, what else can I do with the non-grantor trust? And he says, well, do you have a vacation home? And I said, yes, we do. That's where Marcia goes when she gets tired of me, every single week. So he says, are you deducting the property taxes on your vacation home? No, I'm not, because my whole deduction is only $10,000. Well, the new $40,000 deduction cuts back to $10,000 when your income is $600,000. And because I charge so much in legal fees, I'm stuck at the $10,000. But a non-grantor trust would have up to $40,000. So he says, consider putting your vacation home in a non-grantor trust. Let the non-grantor trust have enough in income to pay those taxes up to $40,000. Well, my taxes are a lot less than $40,000. He says, tell Marcia to get a bigger vacation home. No, I'm not going to tell her that. So what we can do there is put the vacation home into the non-grantor trust. It could be the same non-grantor trust that's making the charitable donations. But if I'm going to put the vacation home in that trust and I'm going to use the trust, is it a non-grantor trust? And the answer may be no, it's a grantor trust. When you put assets in a trust and you have the power to use the trust assets, that's a grantor trust. Now, there is a case called the Gutchess case. And the Gutchess case was a case where a grantor set up a trust, put a house in it. His wife lived in the house, and she let him stay there. Maybe not always, but usually. And the court found that he did not retain an interest. He was only using the house because she was using the house. So what I'm going to do is I'm going to put 25% of that house into the non-grantor trust funded by me. Marcia may put 25% of the house in a non-grantor trust funded by her, or there may be one non-grantor trust. It's easier if there's one, and maybe we put half of the house into the non-grantor trust. We keep the other half. We have the right to use it based upon our half. Our children can use it based upon the half of the non-grantor trust. If you want to be real conservative, it could be 75-25, but at least the taxes paid on the portion of the house in that non-grantor trust are going to be deductible. Now, if you have a vacation lot and you haven't built on it yet, then that would be perfect for the non-grantor trust. And then Jonathan said, so we got charity handled, we got the property taxes on your vacation home. What are you doing for your children? And I said, what do you mean, what am I doing for your children? Are you giving them money? Yeah, maybe I am. A little bit here, a little bit there. Crummy powers, things like that. Well, what if the non-grantor trust gives money to your children and grandchildren and your aunts and your uncles and your parents? Are they in a lower tax bracket than you are? Well, some of them are. Okay, perfect. So the non-grantor trust, put those bonds, put that oil and gas deal in there, the ordinary income investments, part of an S corporation. It can make an SBIT election, part of your business S corp, into a non-grantor trust, which makes an SBIT election. Does that work? Maybe that doesn't work. Never mind. A non-grantor trust owning a partnership interest in your building partnership, which sprays ordinary income to you, which pays charity, pays property taxes, and pays children, grandchildren, aunts, uncles, nephews, nieces, and your tax advisor. So that would be something that could save quite a bit. Some questions. Will the slides be available? Yes. We'll make sure to send them. I apologize that they're not in there now. I thought they were. Second question, will you be done on time? Yes, I promise that I will be done on time. Third question, does this presentation get any better? No, this presentation absolutely does not get any better. Okay, what else can I do with these trusts? Well, I can give somebody with a short life expectancy the power to direct trust assets for in exchange for assets of equal value. And therefore, I can give someone the power to appoint trust assets to creditors of their estate. So if I give my father-in-law the power to appoint trust assets of a particular irrevocable trust that is outside of me, it could be a SLAT, it could be it could be what was a life insurance trust, it could be a grantor trust, it could be a non-grantor trust. It could be over a tree, under a tree, around a tree, near a tree, far from a tree. Whatever it is, on the death of that senior family member, very much sadness in the passing of that person, but a little bit of happiness in a new fair market value income tax basis for the appreciated assets in that trust. So as an alternative for that qualified personal residence trust, you could take the qualified personal residence trust remainder trust once the possessory term is over, and add grandpa as a discretionary beneficiary with court approval, and give grandpa the power to direct trust assets to creditors of his estate, even if it's only with the permission of your next door neighbors acting in a non-fiduciary manner. Then you would have that step up, and on the death of grandpa, and if it's a business building, or you can convert it to a business building, then you'll begin to have the creditor protection that you would expect there. Okay, another observation with 5 minutes remaining, which for many of you is 3/10 of a billable hour. The allocation of assets between a married couple. You know, we've situated assets here and there. People are standing on their heads in awkward, postured yoga poses with complicated charts. And it was all to avoid estate tax. Well, can we simplify that now? And how should these people own their assets? We had them separated out into separate revocable trusts for estate tax purposes. We could put them joint as tenants by the entireties now for creditor protection purposes. If they live in Florida, Delaware, Wyoming, Pennsylvania, or one of the other pure tenancy by the entireties creditor protected jurisdictions. We could form a trust called a joint exempt step-up trust, which would give a new income tax basis on assets in the trust, no matter which spouse dies. So we can concentrate more on the creditor protection and more on the income tax protection, as I said. Another type of trust that we could convert these slats to. Here's this slat. I set it up. It's worth $10 million. I'm happy it's out of my estate, but I'm paying the darn income tax on it. I don't want to do that anymore. And it owes me money. It could pay me money back, maybe at a discount because it's a low interest note. But I could decant that trust, make part of it into a Section 678 trust where it's taxed to a particular child of mine. Maybe a child who is a discretionary beneficiary of the trust, even though Marcia and my descendants will be the primary beneficiaries, it will be taxed at that child's bracket. And that child will be able to use their property taxes up to $10,000 against that income if the child doesn't have a lot of income. And even if it's a child under age 23 who would be subject to the kitty tax, which is a tax imposed upon cats and young adults, if that child provides more than 1/2 of their support, or if they're over 18 and no longer a full-time student, then they can be taxed at their own bracket. So if you buy a big 529 plan for your granddaughter, and then when she's 18 years old, she supports herself from the 529 plan, then you can spray some income at her without giving her a dollar by using a Section 678 trust. And that can work really well for Section 199A planning as well. So all this planning, including the joint exempt step-up trust, redoing buy-sell agreements, they don't have to be Russian roulette anymore, converting them into cross-purchase agreements so that the life insurance is not subject to creditors. Those are all things we can do. In the final minute, I have the slides here, and we will email them to you later. I apologize that they were not part of the downloads, and quite frankly, I don't know how to download them. Peter Farrell and I presented a presentation this week on charitable giving, and this complicated 1/2 of 1% of adjusted gross income cut back in charitable donations that starts in 2026, and the 3/37 limitation on itemized deductions. And my conclusion from that presentation is, number one, I'm real happy with my non-grantor trust because I do not believe that the present statute imposes the 3/37 limitation on a non-grantor trust. Get your charitable your large charitable gifts done this year so you don't have to worry about those limitations. But when you run the numbers on those limitations, it's not a big deal. If you would have had a $370,000 tax savings, now you may have a $350,000 tax savings. Is someone who's going to make $1 million gift going to say, no, I'm not going to make that gift because I only saved $350,000, not $370,000? I think it's more of a headache for planners and a misconception. But you're still going to be able to make the IRA qualified charitable distributions for people over 70 and a half directly from the IRA to the charity. And you're still going to be able to, in my opinion, by my prediction, use the non-grantor trust. So we're going to now switch over to the EstateView software. And as I said before, if you might even want to get onto EstateView while I'm on it here, you would just put EstateView.link in your browser and then go to create a new account. It only asks you for your email address, select Pro Plus, and then put in free trial. That's one word. And then you'll be on EstateView. And when you go to EstateView, the home page looks like this. And the most popular modules for EstateView right now are our AI document review, which I'll show you very quickly because you can go play with it and really have a good time. Our instant plan program, both of these should be out of demo next week, and our married couple program. So I'm going to do this only until 12:20, and if you have questions about it, let me know. When you click on our AI document review program, it says welcome to EstateView AI, and you will click on create a new chat, and then you can choose Google Gemini or OpenAI, which is also Chat GPT. So I prefer Google Gemini. It's faster and it seems to be smarter. Then you can choose which function you want to use, and it will follow our protocols. It will not share your inquiry or your documents with the world. This is all done under a contractual programming arrangement that the Amazon cloud has with each of the AI companies, which enables a software company like mine to have the use of the AI inside your computer. So the document that you load is not seen by a EstateView software company. It's not seen by the Amazon cloud. It flows through your computer. The same thing applies if you have ChatGPT 4.0 or 5.0 and you click to keep private, and that slows it down. So then I can click on one of our functions, such as review a trust or estate document. Then I click on what state law I want to have apply, or whether I don't want a state law to apply. So I can go Florida if I want. Then I can copy and just paste in a Word or PDF document, which can be a trust with all amendments to the trust and a pour over will as one PDF. Or I can go to try a sample document. Then I click on one of these documents, and now it's taking a quick look at the document, and I can ask a question about the document, or I can use EstateView's preloaded protocols, which would be, do I want an executive summary? Do I want a client-friendly summary? Do I want to spot issues? Do I want to analyze tax? Do I want to check for compliance? Or do I want drafting recommendations? So let's just go with tax analysis, compliance check, and drafting recommendations. I click on Run Analysis. Now, it is chunking. And what it's doing is it's taking the document through AI 1,000 words at a time until it's chunked the whole document. And then your computer, using this facility, has created this first part of an executive summary. So it did the executive summary, part one, as to tax implications. Now it's working on the tax analysis. You see there on the right-hand side what it's working on. Now, coming up above, I was able to choose Gemini fast. If I wanted more thoroughness, I could have gone Gemini slow, or I could have clicked on OpenAI. So then, if I want to view the document while it's working on it, I can click View Document, and there's the document that it is working on. And then I can click Hide Document, and you see it's still working. It's not lightning fast because it's chunking at 1,000 words at a time at practically the speed of light. So I may want to go do something else while it's working on this. Pretty soon we will have the ability to have it working on 2 or 3 things at the same time by having multiple chats. But right now, as you can see, it's pumping out all kinds of information. So now it's done with what I asked it to do, and I can copy that onto my computer or I can download it into a Word document. But here's what I really like, and I don't think anyone else is doing this yet. I'm sure someone will eventually. And that is, you see these buttons. I can click a button called Review with Other AI. And when I click on Review with Other AI, it will take the document and the session, and ChatGPT 4.0 will review what Genesis did, or Genesis will review what ChatGPT did. And it's interesting because sometimes it'll say, great job, no problems. And sometimes, quite honestly, it will say, you can't trust it. It made 3 mistakes. Here's the 3 mistakes. And then you can ask it, rerun again with all the mistakes corrected. You basically have 2 AI engines. By that time, you probably go from 90% or 95% accuracy to 96 to 98% accuracy. But I never rely on this. What I use it for is, number one, if I read this for 10 minutes and then the trust for 20 minutes, that's a heck of a lot better than reading the trust for 30 minutes, because this tells me what to look for. Secondly, and you can see how much content it has. Now it's coming up with drafting recommendations. But secondly, it gives the client a nice client-friendly summary of what's going on, and it gives great checklists. I have not found it to miss anything. It may mention a lot of things that I'm not as concerned about, but it's not going to miss anything. And especially like if you have a client moving from Maryland to Florida and they've asked me to review it for Florida law, I'm going to also ask EstateView, what if the person moves back up to Maryland? What's going to be needed if that were to happen? And it will tell me that. And then when I click on Amend Trust, it will give me a prompt, and it'll say, what do you want to amend? Well, I'd like to add a scrivener protector provision. I would like to add my own spendthrift provision. I would like to add powers of appointment if there are no powers of appointment. And I would also like to provide that when Uncle Joe dies, there has to be a trust company as trustee. So that's all set to go. I can, at the end of this session, I can ask for a simplified response. Simplify all this for me, please. Or regenerate it with another software program, or print it or save it. But now it knows it. I want it to amend. So I click Generate Amendment. And now it's generating an amendment. I apologize. I took 10 minutes on this. I just got carried away. But I hope some of you will use this. And most of you are still there. So now let me go back. Let me just restart another version of this. And by the way, next week I'm going to do a program called Jimmy Buffett's Trust. And we're going to go over Jimmy Buffett's trust and what he might have done. So I'm going to go back to EstateView.link, run a second version, and I'm going to go to Instant Plan. And I'm going to concentrate on the intake questions that will fuel my calculators. So you've got Bob Sample, goes by Bobby. He's male. He's 55. He's never used any of his exemption. He would like to retire at age 70. I'm just going to handle the yellow inputs. These are the ones that go into our calculators. He is married. He's a tobacco user, so he's going to have a shorter life expectancy than otherwise. And then we have Mary. She is female. She's age 52, and she's not a tobacco user. And there's a lot of questions here that you would normally ask in a conversation that a client can receive this portal link and fill these questions out, or you can fill them out for them. Then they have a child, Rachel. They have a child, Dale. And they have a child, Marin. They've got grandchildren, Jimmy and Robert. They had a grandchild named Patricia, but she didn't behave, so I'm going to remove her. Okay. Then here's their key financial data. They're saving $350,000 a year. He expects to retire at age 68 and then only save $200,000 a year. And then he feels that when he's age 80, he'll start spending a net of $200,000 a year. So this is working income, pension income, Social Security income, minus spending, minus taxes. This is how much they're adding to savings. You really have to take this into account if you're going to try to predict what their tax situation is. Now, after Bob dies, we expect that Mary will be spending a net of $50,000 a year till she's 75, and then after that, $150,000 a year. Their home is worth $2 million. They expect that it's going to be growing at 4.5%. And he's got a $5,050,000 pension account growing at 7.5%. She's got a $2,750,000 pension account growing at 7.5%. Their assets outside of IRAs in the house, they've got a $7.6 million asset, $100,000 and $100,000. So the total is $7.8 million. So they don't feel estate taxable. He's 60% bonds, 30%. I'm sorry, 60 bonds, 60% stocks, 30% bonds, 5% cash, 5% real estate, and same investment costs and tax costs as you saw before. There's also a little business. We could say it's worth $2.5 million. They expect that they'll sell it for $5.7 million in 5 years. No, I'm sorry. They'll sell it for, let's say, $6.7 million in 5 years, and at that time, pay an income tax of $1.4 million. They would consider a charitable lead annuity trust. And now I'm going to go to life insurance. He's got a $1.5 million life insurance policy. It is not in an ILET. Then he's got another $1.3 million policy, not in an ILET. If we wanted to add a policy, this gives him the rates per million of different kinds of policies, and I would just be able to click on add policy, and then the policy would be added below, but I don't need to add a policy. I can remove that. She has a policy of $1 million. We can say that it's in an ILET, They've got a second to die policy, let's say of $3 million in an islet. And these yellow ribboned items on the left-hand side of my screen are the only ones I need to fill out for the calculators. For their estate planning, there's a lot more information that can be put in there. Liability insurance planning, advisor identification, fiduciaries. You could model out their college spending, but none of those go into our formal calculators. I click on assumptions, and we assume a 40% estate tax rate, 40% gift tax rate, inflation 3.7, chained inflation for the exemption going up 2.96, capital gains rate 23.8. They'd like to retire on, let's say, $2 million a year. They'd like to leave $24 million to their descendants on death. They'll never toggle off grantor trust status, and it would like to see all of our planning techniques. So I click on results, and once it's done, it's just done 50,000 calculations, most of them Monte Carlo calculations. But now I can save this to my calculators. First, I'll go to married comprehensive. So it's assuming that without planning, if they die this year, they're at 21 million, no estate tax, even with the life insurance. Their descendants get $24 million. So they don't have anything to worry about from an estate tax standpoint. We could just go ahead and do all that income tax planning. But her life expectancy is 29 years, and their joint life expectancy, meaning that there's a 50% chance that one of them will live 39 years. And with those numbers, we are looking at a estate tax of $7.7 million. So as you can see, you're looking at a pretty big estate tax. So they may need this planning. So let's go to Save to Calculators. And here I'm going to say Override Existing Calculators. I'm going to click on Save. And now I'm going to go to Married Couple Comprehensive. And here they are again with no planning. And then more definition here. Again, at this point, they're going to need estate tax planning. Oops, I popped out of it. So now let me just show you some other things here. I go back home, and I go back to the instant plan, and I can go to Generate Chart. I click on Generate Chart, and then I click on Sample Planning Chart. It opens up on the top right-hand side of my browser, and I open that up, move it down here, and this is what I have for my first meeting. So for my first meeting, I can make this a bit larger. I've got his IRA minimum distribution planning. So it's showing every other year. He's got $5,050,000 in his IRA growing at 7.5%. His minimum distribution at age 73 will be $671,000. Clients like to see this. It really gives them a sense of security, and this assumes nothing to charity. Now, also I'll show him that if he wants to start giving to charity at 70 and a half, by 2041, when he's 70 and a half, the 105,000 will probably be 193,000, and he can give that part of his minimum distribution to charity, and then his tax savings from charity would be $76,000 his first year. So he may actually want to wait and not give to charity unless he dies early or waits till age 70 and a half, right? But that shows him the numbers. And then over here, I've got whatever information they put on their fillable PDF for their insurances. I've got his individual assets. I have a summary of all their assets, his, hers, and the totals. Totals $22,199,000. And then I've shown his beneficiary for his IRA, the value of the IRA. On the bottom left-hand side, I can see who his pension and investment advisors are. Then I show his occupation and his age. I show the entities he owns and the percentages of ownership and the values. I show their joint assets and their joint companies. I show her pension and IRA accounts, her individual assets, and then also the required minimum distributions for her. And then I have a nice list of their children, grandchildren, family, friends, and fiduciaries. It's really nice when it's right in front of you there. And then I have their family information. And I have what I'm working on with some Stetson Law students right now is the comprehensive red flag report. So Marin's 16. When she's 18, make sure she signs powers of attorney. Jimmy's driving mom's car. Can you get him his own car? Your father is wealthy. Get him to set up a trust for you instead of an outright inheritance. Your mother is not wealthy. Have you done her Medicaid planning? You love your dog, but it's a Dalmatian. It doesn't qualify for most insurance policies. Be careful. You love your dog. Do you want a dog trust? You love your boat more than your dog, but it's 22 feet. Your conventional umbrella probably doesn't cover it. So that list, as you can imagine, goes on and on. It generates a letter which discusses this, and the letter says, talk to the insurance agent about that. Talk to your CPA about that. It can establish a chart of who should be doing what. And then there's a family tree, which is always helpful when it's, well, there's Bobby, and there's Bobby Jr., and then there's Bubby, and there's Bob, and there's Robert. Well, now you can glance down at the family tree and not feel quite as dumb. So then I go back to EstateView. Where did it go? That slippery little program. There it is. Sorry, I'm working with 6 strings. By the way, there's my trust amendment. So, amendment to trust. Let me find the beginning of it. After it does the analysis, I ask it to prepare a trust amendment. And it does prepare a trust amendment. And boy, is this a comprehensive one. Look at how many pages this trust amendment is. The thing is, I don't have to use all these pages. Here's the trust agreement. And the amendment is down here. But if I only use one sentence of the amendment, then I've saved time. And I've helped with my own focus. So going back to an instant plan, the next thing we can do is we can go to export to Excel, and these are different charts. So these charts show you all their assets in columns and show you their liabilities. And on the right-hand side, we'll show you what's foreign and what is community property and what red flags apply to the specific assets. And then we can show them their asset allocation by relative size, relative to value, and then a financial summary, which will become a personal financial statement. Also, going back to results, you've got the family tree, you've got a calendar of their birthdays and holidays, you've got their contacts, you've got their minimum distribution requirements, you've got their retirement analysis as to whether they'll have enough to retire based upon the scenario that we gave them. You've got how much will they save in estate tax if they make a $1 million gift using a 30% discount? How much will they save in estate tax if they put their home in a Cupert with a term of just over 80% of their life expectancy? One half of the house contributed by each of them. How much they can save if they use a self-canceling installment note, and what will the premium rate be or the premium uptick in the note be? How much would they save, and what are the numbers if they want to do a lifetime private annuity on him, on her, or a joint private annuity? What if they do a grantor retained annuity trust? What points of discussion do I want to cover with them for the estate planning in general? And what is a summary of their life insurance policies? Oh, forgot to show you the Monte Carlo analysis. So here's the Monte Carlo analysis. It's an abbreviated Monte Carlo, but based upon 5,050,000, 1/3 in bonds, 2/3 in stocks for 36 years, which was the joint life expectancy. The rate of return, median 9.19, but 10% chance it'll be under 6.92, 10% chance it'll be over 11.44. And look at what difference this makes. The low side, 56 million. The high side, 249 million. And are you running your numbers with both of those scenarios, or only one or the other? So that handles it for both of them. And then, as I said, now I've put all that information into all of these calculators. So now you can go into your conventional sophisticated calculator and say, you know, they do want to do a CLAT. They definitely want to leave something to charity through a charitable lead annuity trust. So with my inputs, I can determine what the best kind of CLAT for them is. They could do a lifetime CLAT, and I compute their present income tax deduction and not only what the remainder interest of this CLAT would be and what the payments would be, but what the present value of the deduction and the remainder interest is. Because it's great to say your children will get $10 million 20 years after you die. What's that worth? $3,900,000. Okay, well, $3,900,000 is good, but don't tell me $10 million. With all these charitable devices, there needs to be truth in giving. And we've worked on that, and EstateView does the best job of any calculator in comparing different scenarios, using multiple scenarios at the same time, and also truth in giving. So that's my advertisement for EstateView. I'm obviously very proud of it and would love to have your input. Have a fantastic rest of your weekend. Appreciate all the people who stick around to watch these presentations. My email address is agassman@gassmanpa.com, as you see here on the bottom of the chart. If you have any questions or suggestions, criticisms, or recipes, send them. Thank you, and have a great weekend.